Good afternoon to you. We are the Prophetic Royal Coat of Arms Ministry, the Reformed Pentecostal Anglo-Saxon and Royal Empire of the Kingdom of God Denomination, and I am Archduke Bishop Dr. Robert L. Maxwell of the Prophetic Royal Coat of Arms, House of Hohenzollern, Duke of Pomerania, Livonia. Colonel of the Royal Guard of Pomerania In, Livonia, Field Marshal of the Prophetic Royal Coat of Arms, Knight of the Sacred and Military Order of Merits of the Prophetic Royal Coat of Arms, and Founder 2005. What does that mean? Bishop of Common Law Ministry, Archduke of Common Law of the Prophetic Royal Coat of Arms Ministry, and the House of Hohenzollern, Duke of Common Law of Pomerania In, Livonia, Colonel of the Royal Guard of Pomerania In, Livonia of Common Law, Field Marshal of the Prophetic Royal Coat of Arms Ministry in the House of Hohenzollern of Common Law, Knight of the Sacred and Military Order of Merit of the Prophetic Royal Coat of Arms Ministry of Common Law, and Founder 2005 of Common Law. Our ministry operates in the jurisdiction of common law. Well, I have a praise report for you, ladies and gentlemen. A while back, I got kicked out of Rosars, and I mentioned that I was going to sue Rosars. Well, I'm happy to say, have that issue resolved and go back to Rosars. And just about a week and a half ago, there's this, at this place, the place will be anonymous. But anyways, I was in this place doing my business, and I mentioned a single comment. I said, looks like you need to upgrade your computer, your printer and stuff. It's one of those old printers where you pull off the edges. Remember those? And he's like, who's going to pay for it? Are you going to pay for it? So it escalated into assault of words, let's put it that way, because he offended my honor. So he offended my honor, and so I had to defend my honor, which I did most certainly. I had absolutely no unction or urge or anything like that to want to punch the guy with my fist. I just wanted to give him a piece of my mind. Long-haired, skinny little guy with tiny mustache and glasses. Very unpleasant person, not very respectful. So there's this little war of words. I left, things calmed down, left, went down to another place, sat down, got arrested, got charged with battery. The guy said, on the ticket said, you insulted me. Said that I assaulted the guy on the arm, which I didn't. Battery. So, I'm happy to report to you that that has been resolved as well. I got it dropped to disturbing the peace, and all I have to do is just pay a fine. So, about a month ago, I was out, month and a half, or maybe less than that, I was out spreading the good news downtown, our little public place. And I ran into this guy calling himself Reverend Jeffrey such and such. Don't remember what the rest of it is. Hand me a couple of flyers, we exchanged polite conversation, gave him one of my business cards, and left. And so, the strangest thing happened, friends, and I kid you not. This is a word of warning to the wise. The guy started leaving messages on my answering service. It started out just a couple of messages every other day. Then it progressed to every single day. Then it progressed to texting. Long, rambling messages of incoherent, no substance, etc., etc. And I'm a pretty tolerant guy. I mean, God accepts all kinds of people, no matter where their intellectual faculties are at. So I tolerated it for, a few days, hoping that it would stop. It didn't. So I text back, said, don't call back, etc. And he got hostile. And then I had to call my service provider and get the numbers blocked and report them to the authorities. And I really hate doing that kind of stuff because we're here to, at this ministry, to invite all kinds of people. And I kid you not, my friends, that was my first stalker that I've ever had. And the male stalker, not which you gotta figure. It's a male stalker. Not some hot, sexy female stalker, but a male stalker. Anyways, so hopefully that issue got resolved. I hate to do that, but I will do that if the messages that I get become aggressive. I mean, because my line's there for people to leave their prayer requests, and I pray over them. So nonetheless, that's the news, because I'm kind of like the Paul Revere preacher out here in Idaho. I tell it how it is, not politically correct. And as you know, if any of you watched any of my messages, you know that's the game. You know why that I had victory over the Rosars issue, so I can go back there. And you know why I had victory over the battery drop to a disturbing the peace ticket is, number one, God Almighty was on my side. Number two, this magic number, discharge without prejudice. Use UCC 1-207, a magic number. And I had some studies on my Google Plus page on this magic number. And don't forget prayer. Because remember, God says that we must obey every single law that the government sets up, unless the law tells you to go against God. The law is in conflict with a Christian theistic worldview, then you're called to act, however that may be. Oh, and that stalker guy accused me of being a fake preacher and teacher and etc. Well, clearly the guy doesn't know the difference between a statutory church and a common law church, which is the jurisdiction which I function under, the common law jurisdiction. And this guy claims to be a reverend, and it ain't my job to judge whether he's saved or not, but his behaviors and actions are not lined up with the Word of God, living for God, serving God. But I'm sure he also has diminishing capacity, a mental problem of some kind, which is no shame in that. You need medications for that. Medication and prayer and service to God, I believe, will help. And so, my friends, in this message, we're going to learn about that magic number. I'm using hyperbole. It's not really a magic number. Of course, you know that. And I'm proud to say to you, my friends, I am no longer a 14th Amendment citizen of the United States of America. It is now to the federal government, alien, and to the state and citizen of the state of Idaho. Of course, I have dual citizenship. I am a British citizen as well. And this little affidavit makes it official, my dear friends. And we're going to learn about this magic number. And maybe you will be able to do the same if you think it is prudent. But that is my situation, my friends. I am alien to the federal government, but a citizen of the state of Idaho and, of course, Great Britain, Imperial Germany as well. So another thing about this stock you didn't understand is he doesn't understand the difference between a statutory church and a common law church or ministry. I don't belong to a 501c3 non-profit corporation, nor am I a corporation in the business of making money. We are a ministry, we are a church. We belong to a family, we belong to an empire, and that kind of language is foreign to the text of Scripture. And I'm telling you, I'm here to tell you another thing that's going to be great. If Donald Trump gets elected, he's going to get rid of the Johnson Amendment, which messed up churches forever when that law was passed, which I believe was 1954. And since 1938, let me put it this way, before 1938, laws dealt with public laws. After 1938, it became public policy. We're also going to look into what that means as well in the studies associated with that magic number I'm telling you about. Not really. And always remember to give God all the credit, any victory you may achieve. And don't make me go through the supreme rulings before 1938. 1938 is the key. And we're going to have to work together to fix this country. People who hold to a Christian theistic worldview. And if you step back and look at the system that we have in the United States of America, and you look what the radical, fanatical, leftist liberals have done to our country since 1938, if you step back, you begin to see the system that the liberals want. This Lenin, Marxist, communist, socialist, radical, fanatical, leftist, liberal, utopian, a godless society indentured to the government, which was not what our country is all about. My friends, you've been duped. You now belong to a completely different country. It's not America. It looks close, though. That's why we need to work together to make some changes and restore this country back to liberties and freedom, unhandicap the First and Second Amendment. Get rid of the 14th Amendment. Moderate or reform the 13th Amendment, because the 13th Amendment and the 14th Amendment created two classes of citizens, federal and state citizens. Before that, it was citizen of the state of California, alien to the federal government. Then the 14th Amendment came along. But the day before the 14th Amendment was passed, a remedy was passed.
Johnson Amendment of 1954 must be appealed, defeat, overthrown, removed, disconnected, undeviating, and permanently. In addition, eliminate and eradicate. Vote for the amputation, removal of the Johnson Amendment. Amen. The Johnson Amendment refers to a change in the U.S. tax code made in 1954, which prohibited tax-exempt organizations from endorsing or opposing political candidates. Proposed by then Senator Lyndon B. Johnson, the amendment affects churches and other non-profit organizations with 550 tax exemptions. Go Trump. K, the CIA. L, Barack Obama. He is a crook and the worst president in history. O, and Trump is going to win. Ha, ha. Sincere leaders charged without prejudice, UCC 1-207 Archduke Drive, Robert L. Maxwell.
The media has become laws against the poor, the destitute, impoverished, inadequate, modest, and the meager has become indentured servants to the government with poverty laws. Furthermore, to be exact, the kind of policies Hillary Clinton wants to continue as Barack Obama has. No substance for substance. We want substance for substance. We want empowerment, and we do not want servitude. We, of all nationalities Americans, are not swallowing, acquisitioning, and buying it no more. Hillary Clinton, we don't want public policies, we want public laws, and goodbye all Johnson Amendment of 1954, amen. Donald Trump has a remedy, unless you don't want a remedy, then vote for Hillary Clinton. Moreover, we, for damn sure are not going to jump onto a table and do a little dance. Hell no. Sincerely. Discharged without prejudice, UCC 1-207. Archduke Dr. Robert L. Maxwell.
The UCC Connection Part 2 did not write. Forward. This is slightly condensed, casually paraphrased transcript of tapes of a seminar given in 1990 by Howard Freeman. It was prepared to make available the knowledge and experience of Mr. Freeman in his search for an accessible and understandable explanation of the confusing state of the government and the courts. It should be helpful to those who may have difficulty learning from such lectures, or those who want to develop a deeper understanding of this information without having to listen to 3 or 4 hours of recorded material. The frustration many Americans feel about our judicial system can be overwhelming and often frightening, and like most fear, eventually, with the seemingly tyrannical power of some governmental agency and the mystifying and awesome power of the courts. We have been taught that we must get a good lawyer, but that is becoming increasingly difficult, if not impossible. If we are defending ourselves from the government, we find that the lawyers quickly take our money, and then tell us as the ship is sinking, "I can't help you with that, I'm an officer of the court." Ultimately, the only way for us to have even a snowball's chance is to understand the rules of the game, and to come to an understanding of the true nature of the law. The attorney lawyers have established and secured a virtual monopoly over this area of human knowledge by implying that the subject is just too difficult for the average person to understand, and by creating a separate vocabulary out of English words of otherwise common usage. While it may, at times, seem hopelessly complicated, it is not that difficult to grasp. Are lawyers as smart as they would have us believe? Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers learn about procedure, not about law. Mr. Freeman admits that he is not a lawyer, and as much, he has a way of explaining law to us that puts it well within our reach. Consider also that the framers of the Constitution wrote in language simple enough that the people could understand, specifically so that it would not have to be interpreted. So again, we find, as in many other areas of life, that the buck stops here. We must take the responsibility for finding and putting to good use the truth. We must claim and defend our God-given rights and our freedom from those who would take from us. We must protect our families, our posterity, from the inevitable intrusion, and ourselves into our lives by those who live parasitically off the labor, skill and talents of others. To these ends, Mr. Freeman offers a simple, hopeful explanation of our plight and a peaceful method of dealing with it. Please take note that this lecture represents one chapter in the book of his understanding, which he is always refining, expanding, improving. It is, as all bits of wisdom are, a point of departure from which to begin our own journey into understanding that we all might be able to pass on to others greater knowledge and hope, and to God, the gift of lives in peace, freedom and praise. I send you out as sheep in the midst of wolves. Be wise as a serpent and harmless as a dove. Introduction. I was asked to testify in a tax case as an expert witness. After many days of preparation, I felt confident of my research. I spent over 30 minutes presenting many Supreme Court decisions that supported the defendant's position. The prosecution concluded his statements, and to my amazement, the judge told the jury that they could only consider certain facts, none of which was the facts I had given. As soon as the trial was over, I went around to the judge's office and he was just coming in through his back door. I said, "Judge, by what authority you overturn the standing decisions of the United States Supreme Court? You sat on the bench while I read the case law. Now how do you, a district judge, have authority to overturn decisions of the Supreme Court?" He says, "Oh, those were old decisions." I said, "Those are standing decisions. They have never been overturned. I don't care how old they are, you have no right to overturn a standing decision of the United States Supreme Court in a district court." Public Law v. Public Policy. He said, "Name any decision of the Supreme Court after 1938 and I'll honor it, but all the decisions you read were prior to 1938, and I don't honor those decisions." I asked what happened in 1938. He said, "Prior to 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge that Mr. S. was being tried for is a public policy statute, not public law, and those Supreme Court cases do not apply to public policy." I asked him what happened in 1938. He said that he had already told me too much, he was not going to tell me anymore. 1938 and the Erie Railroad. Well, I began to investigate. I found that 1938 was the year of the Erie Railroad v. Tompkins case of the Supreme Court. It was also the year the courts claim they blended law with equity. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when a board sticking out of a boxcar as he walked along beside the tracks struck him. The district court had decided based on commercial, negotiable instruments, law, that this man was not under any contract with the Erie Railroad, and therefore he had no standing to sue the company. Under the common law, he was damaged and he would have had the right to sue. This overturned a standing decision of over 100 years. Swift v. Tyson in 1840 was a similar case, and the decision of the Supreme Court was that in any case of this type, the court would judge the case on the common law of the state where the incident occurred, in this case Pennsylvania. Nevertheless, in the Erie Railroad case, the Supreme Court ruled that all federal cases would be judged under the negotiable instruments law. There would be no more decisions based on the common law at the federal level. So here, we find the blending of law with equity. This was a puzzle to me. As I put these new pieces together, I determined that our courts since 1938 were merchant law courts and not common law courts. There were still some pieces of the puzzle missing. A friend in the court. Fortunately, I made a friend of a judge. Now you will not make friends with a judge if you go into court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into court as a wolf, you make demands and tell the judge what the law is, how he had better uphold the law or else. Remember the verse, I send you out as sheep in wolf country, be wise as a serpent and harmless as a dove. We have to go into court and be wise and harmless, and not make demands. We must play a little dumb and ask many questions. Well, I asked many questions and boxed the judges into a corner where they had to give me a victory or admit what they did not want to admit. I won the case, and on the way out, I had to stop by the clerk's office to get some papers. One of the judges stopped and said, "You're an interesting man, Mr. Freeman. If you are ever in town, stop by, and if I am not sitting on a case, we will visit." America is bankrupt. Later, when I went to visit the judge, I told him of my problem with the Supreme Court cases dealing with public policy rather than the public law. He said, in 1938, all the higher judges, the top attorneys and the U.S. attorneys were called into a secret meeting, and this is what we were told. America is a bankrupt nation. It is owned completely by its creditors. The creditors own the Congress, they own the executive, they own the judiciary, and they own all the state governments. Take silent judicial notice of this fact, but never reveal it openly. Your court is operating in an admiralty jurisdiction. Call it anything you want, but do not call it admiralty. Admiralty courts. The reason they cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under the common law. In admiralty, there is no court which has jurisdiction unless there is a valid international contract in dispute. If you know it is admiralty jurisdiction, and they have admitted on the record that you are in admiralty court, you can demand that the international maritime contract, to which you are supposedly a party, and which you supposedly have breached, be placed into evidence. No court has admiralty, maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb. Well, I didn't know that I got involved with an international maritime contract, so, in good faith, I deny that such a contract exists. If this court is taking jurisdiction in admiralty, then, pursuant to section 3501 of your UCC presentment, the prosecutor will have no difficulty placing their alleged contract into evidence, so that I may examine and, possibly, challenge the validity of the contract. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation, and that we are their slaves. Not expedient. However, the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every nation of the world. The reason they do not want to tell everyone that they own everything is that there are still too many privately owned guns. There are uncooperative armies and other military forces. Therefore, until they can gradually consolidate all armies into a world army and all courts into a single world court, it is not expedient to admit the jurisdiction the courts are operating under. When we understand these things, we realize that there are certain secrets they do not want to admit, and we can use this to our benefit. Jurisdiction. The Constitution of the United States mentions 3 areas of jurisdiction in which the courts may operate. Common law. Common law is based on God's law. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do anything you please, as long as you do not infringe on the life, liberty, or property of someone else. You have a right to make a fool of yourself provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any government action which prevents a man from making a fool of him. For instance, when you cross over the state lines in most states, you will see a sign which says, "Buckle your seat belts." It's the law. This cannot be common law, because who would you injure if you did not buckle up? Nobody. This would be compelled performance. Nevertheless, common law cannot compel performance. Any violation of common law is a criminal act, and is punishable. Equity law. Equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So, if you have compelled performance, there must be a contract somewhere, and you are being compelled to perform under the obligation of the contract. Now this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of a contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court, which is a criminal action. Are our seatbelt laws equity laws? No, they are not, because you cannot be penalized or punished for not keeping to the letter of a contract. Admiralty, maritime laws. This is civil jurisdiction of compelled performance, which also has criminal penalties for not adhering to the letter of the contract, but this only applies to international contracts. Now we can see what jurisdiction the seatbelt laws, all traffic codes, etc., are under, whenever there is a penalty for failure to perform, such as willful failure to file. That is admiralty, maritime law, and there must be a valid international contract in force. However, the courts do not want to admit that they are operating under admiralty, maritime jurisdictions, so they took the international law or law merchant and adopted it into our codes. That is what the Supreme Court decided in the Erie Railroad case, that the decisions will be based on commercial law or business law, and that it will have criminal penalties associated with it. Since they were instructed not to call it admiralty jurisdiction, they call it statutory jurisdiction. Courts of contract. You must ask how we got into this situation where we can be charged with failure to wear seatbelts and be fined for it. Is not the judge sworn to uphold the Constitution? Yes, he is. Nevertheless, you must understand the Constitution. In Article I, Section 10, gives us the unlimited right to contract, as long as we do not infringe on the life, liberty or property of someone else. Contracts are enforceable, and the Constitution gives two jurisdictions where contracts can be enforced, equity or admiralty. Nevertheless, we find them being in statutory jurisdiction. This is the embarrassing part for the courts, but we can use this to box the judges into a corner in their own courts. We will cover this more later. Contracts must be voluntary. Under the common law, every contract must be entered into knowingly, voluntarily, and intentionally by both parties, and it is void and enforceable. These are characteristic. It must be based on substance. For example, contracts used to read, for $1 and other valuable considerations, I will paint your house, etc. That was a valid contract. The dollar was a genuine, silver dollar. Now, suppose you wrote a contract that said, for one Federal Reserve note and other considerations, I will paint your house. In addition, suppose, for example, I painted your house the wrong color. Could you go into a common law court and get justice? No, you could not. You see, a Federal Reserve note is a colorable $1, as it has no substance, and in a common law jurisdiction, that contract would be unenforceable. Colorable money, colorable courts. The word colorable means something that appears to be genuine, but is not. Maybe it looks like $1, and maybe it spends like $1, but if it is not redeemable for lawful money, silver or gold, it is colorable. If a Federal Reserve note is used in a contract, then the contract becomes a colorable contract. In addition, colorable contracts must be enforced under a colorable jurisdiction. Therefore, by creating Federal Reserve notes, the government had to create a jurisdiction to cover the kinds of contracts which use them. We now have what is called statutory jurisdiction, which is not a genuine admiralty jurisdiction. One colorable, that which is in appearance only, and not in reality, what it purports to be, hence counterfeit. Feigned have the appearance of truth. Black's Law Dictionary, 6th edition. It is colorable admiralty jurisdiction the judges are enforcing because we are using colorable money. Colorable admiralty is now known as statutory jurisdiction. Let us...
Our scripture for the day is Matthew 10, verse 16 and following. I am sending you out like sheep among wolves, therefore be shrewd as snakes and innocent as doves. Be on your guard. You will be handed over to the local councils and be flogged in the synagogues. Of course, we know what that's referring to. That's referring to the God's elect and very elect being persecuted after death, burial, and resurrection. Well, as well, they were persecuted during Christ's mission on earth.
See how we got under this statutory jurisdiction. Uniform Commercial Code. The government set up a colorable law system to fit the colorable currency. It used to be called the law merchant or the law of redeemable instruments, because it dealt with paper, which was redeemable in something of substance. However, once Federal Reserve notes had become unredeemable, there had to be a system of law, which was completely colorable from start to finish. This system of law was codified as the Uniform Commercial Code. In addition, has been adopted in every state. This is colorable law, and it is used in all the courts. I explained one of the keys earlier, which is that the country is bankrupt and we have no rights. If the master says, jump, then the slave had better jump, because the master has the right to cut off his head. As slaves, we have no rights. Nevertheless, the creditors, masters had to cover that up, so they created a system of law called the Uniform Commercial Code. This colorable jurisdiction under the Uniform Commercial Code is the next key to understanding what happened. Contract or agreement. One difference between common law and the Uniform Commercial Code is that in common law, contracts must be entered into, 1. knowingly, 2. voluntarily, and 3. intentionally. Under the UCC, this is not so. First, contracts are
And another interesting fact, my dear friends, is we have a system that is anti-Christ, anti-Christian theistic worldview, a system that the liberals want to create, their utopian vision on earth. No God and slave to the government. And you begin to see some characteristics. I ain't going to tell you any more about that. Or maybe I will.
Under this new law, agreements can be binding, and if you only exercise the benefits of an agreement, it is presumed or implied that you intend to meet the obligations associated with those benefits. If you accept a benefit offered by government, then you are obligated to follow, to the letter, each statute involved with that benefit. The method has been to get everyone exercising a benefit. In addition, they do not even have to tell the people what the benefit is. Some people think it is the driver's license, the marriage license or the birth certificate, etc. I believe it is none of these. Compelled benefit. I believe the benefit being used is that we have been given the privilege of discharging debt with limited liability, instead of paying debt. When we pay a debt, we give substance for substance. If I buy a quart of milk with a silver dollar, that dollar bought the milk, and the milk bought the dollar. Substance for substance. However, if I use a Federal Reserve note to buy the milk, I have not paid for it. There is no substance in the Federal Reserve note. It is worthless paper given in exchange for something of substantive value. Congress offers us this benefit. Debt money, created by the federal United States, can be spent all over the United States of America. It will be legal tender for all debts, public and private, and the limited liability is that you cannot be sued for not paying your debt. So now, they have said, we're going to help you out and you can just discharge your debts instead of paying your debts. When we use this colorable money to discharge our debts, we cannot use a common law court. We can only use a colorable court. We are completely under the UCC, using non-redeemable negotiable instruments, and we are discharging debt rather than paying debt. Remedy and recourse. Every system of civilized law must have two characteristics, remedy and recourse. Remedy is a way to get out from under that law, and you recover your loss. The common law, the law merchants, and even the Uniform Commercial Code all have remedy and recourse, but for a long time we could not find them. If you go to a law library and ask to see the Uniform Commercial Code, they will show you a shelf of books completely filled with the Uniform Commercial Code. When you pick up one volume and start to read it, it will seem to have been intentionally written to be confusing. It took us a long time to discover where the remedy and recourse are found in their UCC. They are found right in the first volume, at 1-308, old 1-207. and 1-103, remedy. The making of a valid reservation of rights preserves whatever rights the person then possesses, and prevents the loss of such rights by application of concepts of waiver or estoppels. UCC 1-308, old 1-207. 7. It is important to remember when we go into a court that we are in a commercial international jurisdiction. If we go into court and say, I demand my constitutional rights, the judge will most likely say, you mention the Constitution again, and I'll find you in contempt of court. Then we do not understand how he can do that. Has not he sworn to uphold the Constitution? The rule here is, you cannot be charged under one jurisdiction, and defend under another. For example, if the French government came to you and asked where you filed your French income tax in a certain year, do you go to the French government and say, I demand my constitutional right? No. The proper answer is, the law does not apply to me, I am not a Frenchman. You must make your reservation of rights under the jurisdiction in which you are charged, not under some other jurisdiction. So in a UCC court, you must claim your reservation of rights under, pursuant to, their, UCC 1-308, old 1-207. UCC 1-308, old 1-207, goes on to say, when a weighable right or claim is involved, the failure to make a reservation thereof causes a loss of the right, and bars its assertion later. UCC 1-308, old 1-207. 9. You have to make your claim known early. Further, it says, the sufficiency of the reservation, any expression indicating an intention to reserve rights, is sufficient. Such as without prejudice, UCC 1-308, old 1-207. 4. Whenever you sign any legal paper that deals with Federal Reserve notes, FRNs, in any way, shape or manner, under your signature right, without prejudice UCC 1-308, old 1-207. This reserves your rights. You can show, at 1-308, old 1-207, for that you have sufficiently reserved your rights. It is very important to understand just what this means. For example, one man who used this in regard to a traffic ticket was asked by the judge just what he meant by writing without prejudice UCC 1-308, old 1-207, on his statement to the court. He had not tried to understand the concepts involved. He only wanted to use it to get out of the ticket. He did not know what it meant. When the judge asked him what he meant by signing in that way, he told the judge that he was not prejudiced against anyone. The judge knew that the man had no idea what it meant, and fined him an additional $25 for a frivolous defense. You must know what it means. Without prejudice. Pursuant to UCC 1-308. When you see without prejudice UCC 1-308 in connection with your signature, you are saying, I reserve my right not to be compelled to perform under any contract, commercial agreement or bankruptcy that I did not enter knowingly, voluntarily, and intentionally. And furthermore, I do not and will not accept the liability of the compelled benefit of any unraveled contract or commercial agreement or bankruptcy. Actually, it is better to use a rubber stamp, because this demonstrates that you had previously reserved your rights. The simple fact that it takes several days or a week to order and get a stamp shows that you had reserved your rights before signing the document. What is the compelled performance of an unraveled commercial agreement? When you use Federal Reserve notes instead of silver dollars, is it voluntary? No. There is no lawful money, so you have to use Federal Reserve notes. You have to accept the benefit. The government has given you the benefit to discharge your debts with limited liability, and you do not have to pay your debts. How nice they are. But if you did not reserve your rights under 1-308, old 1-207, 7, you are compelled to accept the benefit, and are therefore obligated to obey every statute, ordinance and regulation of the government, at all levels of government, federal, state and local. If you understand this, you will be asked to explain it to the judge when asks. In addition, he will ask, so be prepared to explain it to the court. You will also need to understand UCC 103, the argument and recourse. If you want to understand this fully, go to a law library and photocopy these two sections from the UCC. It is important to get the Anderson, Uniform Commercial Code, Lawyers Cooperative Publishing Company, edition. Some of the law libraries will only have the West Publishing version, and it is very difficult to understand. In Anderson, it is broken down with decimals into 10 parts, and most importantly, it is written in plain English. Recourse. The recourse appears in the Uniform Commercial Code at 103.6, which says, the code is complementary to the common law, which remains in force, except where displaced by the code. A statute should be construed in harmony with the common law, unless there is a clear legislative intent to abrogate the common law. This is the argument we use in court. The code recognizes the common law. If it did not recognize the common law, the government would have had to admit that the United States is bankrupt, and is completely owned by its creditors. Nevertheless, it is not expedient to admit this, so the code was written so as not to abolish the common law entirely. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights at 1-308, old 1-207, you may then insist that the statutes are construed in harmony with the common law. If the charge is traffic, you may demand that the court produce the injured person who has filed a verified complaint. If, for example, you were charged with failure to buckle your seatbelt, you may ask the court who was injured because of your failure to buckle up. However, if the judge will not listen to you and just moves ahead with the case, then you will want to read to him that last sentence of 103.6, which states, the code cannot be read to preclude a common law action. Tell the judge, Your Honor, I can sue you under the common law, for violating my right under the Uniform Commercial Code. I have a remedy, under there, UCC, to reserve my rights under the common law. I have exercised the remedy, and now you must construe this statute in harmony with the common law. You must come forth with the damaged party. If the judge insists on proceeding with the case, just act confused and ask this question. Let me see if I understand, Your Honor. Has this court made a judicial determination that the sections 1-308, old 1-207, and 1-103 of the Uniform Commercial Code, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he answers, yes, then you say, I put this court on notice that I am appealing your judicial determination. Of course, the higher court will uphold the code on appeal. The judge knows this, so once again you have boxed him into a corner. Practical application, traffic court. Just so we can understand how this whole process works, let us look at a court situation such as a traffic violation. Assume you ran through a yellow light and a police officer gave you a traffic ticket. 1. The first thing you want to do is to delay the action at least 3 weeks. This you can do by being pleasant and cooperative with the officer. Explain to him that you are very busy and ask if he could please set your court appearance for about 3 weeks away. At this point, we need to remember the government's trick. I'm from the government, and I'm here to help you. Now we want to use this approach with them. 2. The next step is to go to the clerk of the traffic court and say, I believe it would be helpful if I talk to you, because I want to save the government some money. This will get their attention. I am undoubtedly going to appeal this case. As you know, in an appeal, I have to have a transcript, but the traffic court does not have a court reporter. It would be a waste of taxpayers' money to run me through this court and then to have to give me a trial de novo in a court of record. I do need a transcript for appealing, and to save the government some money, maybe you could schedule me to appear in a court of record. You can show the date on the ticket and the clerk will usually agree that there is plenty of time to schedule your trial for a court of record. Now your first appearance is in a court of record and not in a traffic court, where there is no record. 3. When you get into court, the judge will read the charges, driving through a yellow light or whatever, and this is a violation of ordinance size. He will ask, do you understand the charges against you? 4. It is very important to get it read into the record that you do not understand the charges. With that in the record, the court cannot move forward to judge the facts. This will be answered later. 5. Well, Your Honor, there is a question I would like to ask before I can make a plea of innocent or guilty. I think it could be answered if I could put the officer on the stand for a moment and ask him a few short questions. Judge, I don't see why not. Let's swear the officer in and have him take the stand. Is this the instrument that you gave me? Handing him the traffic citation. Officer, yes, this is a copy of it. The judge has the other portion of it. Where did you get my address that you wrote on that citation? Officer, well, I got it from your driver's license. Handing the officer your driver's license, is this the document you copied my name and address from? Officer, yes, this is where I got it. While you've got it in your hand, would you read the signature that's on that license? The officer reads the signature. While you're there, would you read into the record what it says under the signature? Officer, it says, without prejudice, UCC 1308, Old 1 207. Judge, let me see that license. He looks at it, turns to the officer. You didn't notice this printing under the signature on this license, when you copied his name and address onto the ticket? Officer, oh, no, I was just getting the address, I didn't look down there. Judge, you're not very observant as an officer. Therefore, I am afraid I cannot accept your testimony in regards to the facts of this case. This case is dismissed. 6. A. You had reserved your common law rights under the UCC. B. You had done it sufficiently by writing without prejudice, UCC 1308, Old 1 207, on your driver's license. C. The statute would now have to be read on harmony with the common law, and the common law says the statute exists, but there is no injured party, and D. Since there is no injured party or complaining witness, the court has no jurisdiction under the common law. 5. If the judge tries to move ahead and try the facts of the case, then you will want to ask him the following question. Your Honor, let me understand this correctly. Has the court made a judicial determination that it has authority under the jurisdiction that it is operating under, to ignore 2 sections of the Uniform Commercial Code which have been called to its attention? If he says, yes, tell him that you put the court on notice that you will appeal the judicial determination, and that if you are damaged by his actions, you will sue him in common law action, under the jurisdiction of the UCC. Questions and review. Note, these are some of the questions asked after the main lecture. Some are restatements of material presented earlier, but they contain very valuable information, which is worth repeating. Courtroom techniques. Question: how did you box in the judge? This is easy to do if you do not know too much. I did not know too much, but I boxed them in. You must play a little ignorant. If you are arrested and you go to court, just remember that in a criminal action, you have to understand the law, or it is a reversible error for the court to try you. If you do not understand the law, they cannot try you. In any traffic court case or tax case, you are called into court and the judge reads the law and then asks, do you understand the charges? Defendant: no, Your Honor, I do not. Judge: well, what is so difficult about the charge? Either you drove the wrong way on a one-way street or you did not. You can only go one way on that street, and if you go the other way, it is a $50 fine. What's so difficult about this that you don't understand? D: well, Your Honor, it is not the letter of the law, but rather the nature of the law that I do not understand. The Sixth Amendment of the Constitution gives me the right to request the court to explain the nature of any action against me, and upon my request, the court has the duty to answer. I have a question about the nature of this action. J: well, what is that? What do you want to know? Always ask them some easy questions first, as this establishes that they are answering. You ask. D: well, Your Honor, is this a civil or criminal action? J: it is criminal. If it were a civil action there could be no fine, so it has to be criminal. D: thank you, Your Honor, for telling me that. Then the record will show that this action against straw man name is a criminal action. Is that right? J: yes. D: I would like to ask another question about this criminal action. There are two criminal jurisdictions mentioned in the Constitution. One is under the common law, and the other deals with international maritime contracts, under an admiralty jurisdiction. Equity is civil, and you said this is a criminal action, so it seems it would have to be under either the common law, or maritime law. However, what puzzles me, Your Honor, is, there is no corpus delicti here that gives this court a jurisdiction over my person and property under the common law. Therefore, it does not appear to me that this court is moving under the common law. J: no, I can assure you this court is not moving under the common law. D: well, thank you, Your Honor, but now you make the charge against me even more difficult to understand. The only other criminal jurisdiction would apply only if there was an international maritime contract involved and I was a party to it. It had been breached, and the court was operating in an admiralty jurisdiction. I do not believe I have ever been under any international maritime contract, so I would deny that one exists. I would have to demand that such a contract, if it does exist, be placed into evidence, so that I may contest it, but surely, this court is not operating under an admiralty jurisdiction. You just put words in the judge's mouth. J: no, I can assure you, we are not operating under an admiralty jurisdiction. We are not out in the ocean somewhere, we are right here in the middle of the state of North Carolina. No, this is not an admiralty jurisdiction. D: thank you, Your Honor, but now am I more puzzled than ever. If these charges are not under the common law, or under admiralty, and those are the only criminal jurisdictions mentioned in the Constitution, what kind of jurisdiction could this court be operating under? J: it's statutory jurisdiction. D: oh, thank you, Your Honor. I am glad you told me that. However, I have never heard of that jurisdiction. Therefore, if I have to defend under that, I would need to have the rules of criminal procedure for statutory jurisdiction. Can you provide me with the location of a copy? I have exercised, and shall exercise my rights under UCC 1308-1207. What is the compelled performance of an unraveled commercial agreement? When you use Federal Reserve notes instead of silver dollars, is it voluntary? No. There is no lawful money or alternative, so you have to use Federal Reserve notes. You have to accept the benefit. The government has given you the benefit to discharge your debts with limited liability, and you do not have to pay your debts. How nice they are. But if you did not reserve your rights under 1207.7, you are compelled to accept the benefit, and are therefore obliged to obey every statute, ordinance, and regulation of the government, at all levels of government, federal, state and local. If you understand this, you will be able to explain it to the judge when he asks. In addition, he will ask, so be prepared to explain it to the court. You will also need to understand UCC 103, the argument and recourse. If you want to understand this fully, go to a law library and photocopy these two sections from the UCC. It is important to get the Anderson, 3rd edition. Some of the law libraries will only have the West Publishing version, and it is very difficult to understand. In Anderson, it is broken down with decimals into 10 parts and, most importantly, it is written in plain English. Recourse. The recourse appears in the Uniform Commercial Code at 103.6, which says, the code is complementary to the common law, which remains in force, except where displaced by the code. A statute should be construed in harmony with the common law, unless there is a clear legislative intent to abrogate the common law. UCC 103.6. This is the argument we use in court. The code recognizes the common law. If it did not recognize the common law, the government would have to admit that the United States is bankrupt, and is completely owned by its creditors. Nevertheless, it is not expedient to admit this, so the code was written so as not to abolish the common law entirely. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights at 1207, you may then insist that the statutes be construed in harmony with the common law. If the charge is a traffic ticket, you may demand that the court produce the injured person who has filed a verified complaint. If, for example, you were charged with failure to buckle your seat belt, you may ask the court, who was injured as a result of your failure to buckle up. However, if the judge won't listen to you and just moves ahead with the case, then you will want to read to him the last sentence of 103.6, which states, actually, it is better to use a rubber stamp, because this demonstrates that you had previously reserved your rights. The simple fact that it takes several days or a week to order and get a stamp shows that you had reserved your rights before signing the document. Anderson Uniform Commercial Code Lawyers Cooperative Publishing Co. The code cannot be read to preclude a common law section. Tell the judge, Your Honor, I can sue you under the common law for violating my rights under the Uniform Commercial Code. I have a remedy, under the UCC, to reserve my rights under the common law. I have exercised the remedy, and now you must construe this statute in harmony with the common law. To be in harmony with the common law, you must come forth with the damaged party. If the judge insists on proceeding with the case, just act confused and ask this question: let me see if I understand. Your Honor, has this court made a legal determination that sections 1207 and 103 of the Uniform Commercial Code, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he answers, yes, then you say, I put this court on notice that I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge knows this, so once again you have boxed him in. Explain UCC 1207. If you are confronted with explaining what the UCC 1207 does, here is your answer. When you are going to sign a contract, driver's license, lease, buying a automobile, snowmobile, a building permit, marriage license, divorce decree. On the other hand, any other document. Before you sign, you have the right to draw a fine line through anything that is not to your liking. It can be a number, a letter, a word, or a group of words. At this time you can add anything you want in the contract. Any changes you have made, sign your name close to it and date it. A contract is to have the entire contract in full disclosure at the time of signing. If not, the UCC 1207 will stop you from giving up your rights on the contract. You are about to sign and void out any part of the contract that you have not had the opportunity to view. Now how the UCC 1207 works. After you put UCC 1207 where your signature is going to be, your signature is the last thing you put on the document. When you pick up your pen from the signed contract, it is consummated. You have given up your right to change the contract. Here is some more UCC information. You can go to a public law library for more information. Read the full article. UCC 1207 discussion. If you are confronted with explaining what the UCC 1207 does, here is your answer. When you are going to sign a contract, driver's license, lease, buying a automobile, snowmobile, a building permit, marriage license, divorce decree. Alternatively, any other document. Before you sign, you have the right to draw a fine line through anything that is not to your liking. It can be a number, a letter, a word, or a group of words. At this time you can add anything you want in the contract. Any changes you have made, sign your name close to it and date it. A contract is to have the entire contract in full disclosure at the time of signing. If not, the UCC 1207 will stop you from giving up your rights on the contract. You are about to sign and void out any part of the contract that you have not had the opportunity to view. Now how the UCC 1207 works. After you put UCC 1207 where your signature is going to be, your signature is the last thing you put on the document. When you pick up your pen from the signed contract, it is consummated. You have given up your right to change the contract. Here is some more UCC information. You can go to a public law library for more information. Read the full article. UCC 1207 discussion. Government has no jurisdiction under the Constitution. Important, UCC 1207 has been moved to UCC 1308 to hide it from the public. In addition, you will need to make written motions along with the verbal procedure in court. In this article, the UCC connection. Additionally, lower-level state courts and magistrates will not know what you are talking about. You have to either appeal to a higher court or ask for a real judge. In federal court, they will offer you a magistrate. Never accept a magistrate. You always want a real judge. I have enclosed a notification of reservation of rights. Make sure you get it notarized and then file it with the county to make it public record. This is usually the same place that you file a marriage license. After they stamp it filed, then make several copies and send it to real judges on the state and federal level. Certified mail and return receipt. If signature is refused, then just send it first-class mail and they are then responsible for its knowledge. Be sure to keep all of your mail receipts. Do not send it to magistrates or judges that only try traffic tickets and dog bites, etc. Send it to real judges that try real felonies. It will take about 15 to 30 days, but there will never be a warrant issued for your arrest, or to search your property unless you actually harm someone. Also, so you should not get a traffic ticket. Sometimes, the judges fail to put you on the list for diplomatic immunity if you do get a traffic ticket. Then just appeal the decision of the traffic ticket court to the next court up and file a motion to dismiss because of reservation of rights. Then you may never hear from them again, or they will drag it out up to a year trying to wear you down or scare you into a plea bargain. However, stick to your guns and do not give in. There is nothing they can do. The fact is that he will never rule on your motion but continue to drag out the case until they can no longer try you. This is usually 12 months. Then you file a motion to dismiss because you did not receive a speedy trial to test for diplomatic immunity. How the UCC 1308 works. Compare that the Constitution for the US establishes for the court's jurisdiction at common law, equity and admiralty under Article 3. As opposed to this, the Federal Corporation establishes a similar jurisdiction except as principles under the Uniform Commercial Code. See UCC Section 103. Supplementary General Principles of Law applicable. Unless displaced by the particular provisions of this Act, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppels, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause shall supplement its provisions. Any time you see a law by itself as in the foregoing, it means the common law. Except that, they are taking the common law jurisdiction from the contract, the UCC. The remedy of course is UCC 1308. Therefore, the UCC is a deceptive criminal contractual constitution of sorts to those who uses it against us. UCC 1308 is the remedy for any legal process under commercial law in the US. UCC Section 1308. Performance or acceptance under reservation of rights. A party that with explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, or the like are sufficient. Since the Federal Corporation is just that, a corporation, it has no jurisdiction except with those that contract with it. Also see Congressional Act of 1871 and U.S.C. Title 28, Part 6, Chapter 176, Subchapter 176, Subsection A, 3002. 15. United States means a federal corporation. The states illegally contracted with the Federal Corporation by passing the Uniform Commercial Code, making themselves as well as the unsuspecting people subject to the Federal Corporation and to the states in their new commercial capacities. Therefore, all of the laws, color of law, are contractual commercial laws and the remedy is UCC 1308. The Uniform Commercial Code makes all crimes commercial only by contractors per 27 CFR 72.11. The problem is that you have to get into higher courts before they will recognize the remedy. The remedy, however, should legally and always be given immediately on demand or claim. This, of course, is the problem. The misdemeanor courts do not have a clue as to where their jurisdiction comes from, and neither do magistrates. You have to get in front of a court with a real judge that tries felonies. The courts try to string you along under duress of threat, hoping that you can be scared into a plea. However, they in the end have to honor the remedy. 27 CFR 72.11 Part 72 Disposition of Seized Personal Property Table of Contents. Subpart B Definitions Commercial Crimes. Any of the following types of crimes, federal or state, offenses against the revenue laws: burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling and confidence games, and attempting to commit, conspiring to commit. Alternatively, compounding any of the foregoing crimes, addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. Last note, the 14th Amendment actually creates a lower class of citizen of the United States rather than the higher citizenship of one of the several states of the Union. The remedy provided to the 14th Amendment is an act by Congress known as 15 United States Statute at Large, July 27, 1868, one day before the 14th Amendment took effect, and also known as the Expatriation Statute. This is your remedy to claim to be a natural citizen of your state. This makes you a higher citizen and no longer subject to the Article 4 loophole that deprives you of your rights. Notification of reservation of rights.